Thank you all for being here. As a native of Washington State, I feel compelled to add a completely irrelevant footnote. At this very hour, the University of Washington and the University of Colorado are engaged in combat on the football field at the University of Colorado. Presumably under state law, both teams can be stoned out of their minds. I don't know how the coaches would feel about that. Oh, dear. To be more serious for a moment, I want to abandon levity and try and be serious about the Constitution. A few years ago, Justice Sandra Day O'Connor wrote in an opinion, "Some truths are so basic that, like the air around us, they are easily overlooked." And I want to talk about one of those truths, which Michelle has sort of brought to our attention, but I'm going to take it in a different direction and focus on it a little bit more directly. When the framers met in Philadelphia in the summer of 1787, they were intent on creating a national government that would be effective and that would give considerable power to that new national government, but they were also equally concerned about making sure that that new national government wouldn't abuse the liberties of American citizens. So we tend to think of the Bill of Rights and the various amendments to the Constitution as being the mechanisms for preservation of our personal liberties. But the framers didn't include the Bill of Rights in that Constitution when they sent it out for ratification, yet that had been one of their concerns, to preserve American liberties. Instead, the device that they chose to preserve liberty was at that time unprecedented, though we don't give it much thought today. The usual assumption at that time was that a government had complete power to do whatever it thought was appropriate to deal with the health, welfare, and safety of its citizens. And limited only to the extent that some charter of government might place limitations upon that. But the framers reversed that assumption. They said the federal government has no power to do anything, nothing, unless that power has been given to it in the Constitution. So by that, they intended to create a situation where powers were limited, and they assumed that liberty would exist in the absence of powers. Now, we tend today to think of liberties as trump cards, that somehow they trump the exercise of powers. But the framers didn't necessarily think of it that way. It's okay to think of liberties as trump cards, but it's also important to think about the limitations upon powers as an aspect of the preservation of liberty. Of course, the federal government was given some very important powers. Michelle has mentioned one of the most important, the power to regulate interstate commerce, interstate foreign commerce, commerce with the Indian tribes. But there's a lot of other powers: power to tax the people, power to borrow, the power to spend money, the power to conduct foreign affairs, and there are a host of others, some more or less important. But Congress was given also considerable discretion as to how to implement those powers in what we know as the necessary and proper clause, or as I sometimes like to prefer to call it, the means enabling power. Essentially, that Congress has a considerable discretion to choose the means by which it would seek to implement its enumerated powers. And that's been true for a very long time, beginning with a case decided by the John Marshall Court back in the early 1800s. However, the original Constitution, the one that was submitted to the states for ratification, didn't contain any obvious limitation upon the scope of those powers. It was one thing to say that the national government had no authority to act unless it was given a specific power. It's quite another to say what the scope of those specific powers might be. And it was that omission that caused the opponents of the Constitution to resist ratification, or as a fallback to urge that a Bill of Rights be enacted. Congress did so, enacting and states ratifying the first 10 amendments, which we know as the Bill of Rights. Among those amendments are the 9th and 10th Amendments, frequently overlooked, and sometimes people don't even think of them as the Bill of Rights. The 10th Amendment states a truism, but it is an important truism. The powers not delegated to the United States by this Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. That last clause, or to the people, essentially means that the people of every state have the ability to place limits upon the exercise of the authority that might be used by their state representatives. They can do so in their state constitutions. So effectively, what states a truism. Where federal power ends, state power begins, but it doesn't tell us much about where federal power ends. The Ninth Amendment is a bit more opaque and hasn't, unfortunately, meant very much in American constitutional law. But I'm going to subject you to a little bit more discourse about the Ninth Amendment. The Ninth Amendment says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now, there were two reasons for the Ninth Amendment. One was to ensure that the list of individual rights in the Bill of Rights was not exhaustive. So, for example, you put out a list, you might then reasonably think, well, there are no more. That's it. And the Ninth Amendment was designed to rebut that conclusion. And it has borne fruit, indirectly, by a whole host of rights that are not enumerated in the Constitution. Among them are some that we think as absolutely rock-bottom basic. The right to be presumed innocent until proven guilty. Nowhere mentioned in the Constitution. More latter versions of these unenumerated rights might be the right to use contraceptives, the right to abort a fetus before fetal viability, and many more. But there was another reason for the Ninth Amendment, and that's the one that I want to fasten on for the moment. Because the original Constitution placed no limitation upon the scope of the rights that were, or powers rather, that were given to the federal Constitution, some people thought that the government might have implied power to do things like banning the interstate shipment of books or requiring people who'd robbed the mails to testify against themselves. Now, the Bill of Rights took care of that by saying, no, you can't ban the interstate shipment of books. Freedom of speech takes care of that. You can't force people to testify against themselves. The Fifth Amendment's privilege against self-incrimination takes care of that. But nonetheless, by enacting those amendments, that might lead to the conclusion that we had to enact them because there were some indefinite implied powers that the federal government had that we had to curb by enacting these specific amendments. And it's that the Ninth Amendment also was intended to safeguard against. The implication that the scope of the enumerated powers is so broad that Congress can do effectively anything it wants. Now, constitutional history is filled with lots of eddies and detours. And what happened here, though I wouldn't say it's related to the Ninth Amendment, is, of course, very shortly, the Supreme Court assumed the power of judicial review, the power to declare what constitutional law is, and as Professor Beatty has said, just to strike down those laws that are inconsistent with the Constitution. None of us have any quarrel, or very few of us have any quarrel. I should probably say it's probably not unanimous. There's some wackos out there who object to judicial review, but all of us accept it. And for most of our nation, we've relied upon the Supreme Court to be the entity to declare what the scope of those enumerated powers are. But beginning in the 1930s, the Supreme Court took a new tack. It basically adopted a position of deference to Congress's choice as to the scope of its own powers. It did so essentially by saying that so long as the court could imagine any rational connection, any rational reason why Congress thought its legislation was related to an enumerated power of Congress, the court would bless the legislation. So not surprisingly, over time, Congress has begun to think of itself as possessing a pretty unlimited reservoir of power to address whatever it thinks is important. And the catch-all provision of interstate commerce is the one that is principally relied upon. Now, in a globally interdependent world where everything seems to be a commodity, as Michelle mentioned, the Supreme Court in the Gonzalez against Raich case, the California medical marijuana case, sort of speaks of the interstate commerce powers being related to regulation of anything that's a commodity. Almost anything can be commodified in this increasingly materialistic and interdependent world. And if that is the case, If everything is commercial, then there is nothing that is beyond the scope of Congress's regulatory authority. But that is precisely what is forbidden by the structure of the Constitution. So the federal government has limited power, and the framers intended it to have limited power. Had they wanted to give the federal government unlimited power, they had looked no further than King George's Parliament, which provided a very ready example. And that was an example that they clearly rejected and spent a lot of time and money and blood in order to do so. So granting Congress a virtually unreviewable power to decide upon the scope of its own authority is akin to naming the poacher to be the game warden. It's true that in recent years the court has taken some baby steps to reassert itself as the proper interpreter of the scope of the enumerated powers of the federal government. But like all baby steps, the courts have been unsteady, insecure, and uneven and uncertain. Now, left unused has been the constitutional mandate of the Ninth Amendment. The enumeration of certain rights in the Constitution, it says, shall not be construed to deny or disparage the rights retained by the people. There are two issues of significance that I put to you flow from that statement. First, it's a principle of construction, how to construe the Constitution. It's a directive to courts, among others, to construe the Constitution in a way that does not deny or disparage the people's retained rights. Now, what are those retained rights? That's a highly controversial issue, but one of them surely must be the retained right of the people, a right recognized by the 10th Amendment, to self-governance within each state. After all, it is a truism, but it recites a structural principle that the people of each state are entitled to govern themselves underneath the umbrella of the federal Constitution. We're not talking about violating any of the federal constitutional rights that are contained in what we might think of as the Bill of Rights and the various constitutional amendments. But within that umbrella, a retained right is that right of self-governance. So to the extent that Congress is given the power to impose a uniform national rule on just about any aspect of human behavior, that right of local self-governance is gutted. And the Ninth Amendment admonishes, indeed it commands, courts not to let that happen. So the method of preventing the loss of this retained right is to construe the enumerated rights that are given to the federal government by the Constitution as limited in scope, not as an unlimited fountain of power. To quote Justice O'Connor once again, the judicial task is to divine or to create objective markers, she says, of the boundaries of federal power. The frontier federal power is not a will-o'-the-wisp. It's not a mirage. It's a border, and borders that aren't marked and monitored are no borders at all. So it's become vogue in our political discourse to assume that once a problem is identified, the obvious solution is a national one. And that may be sometimes efficient, but it is neither consistent with the fundamental structure of the Constitution nor the promise of personal liberty. That is our legacy, and that is embodied in that structural principle. Professor Raposinski once wrote, "If the federal government is ever captured by an authoritarian movement, the resulting oppression would almost certainly be much more severe and durable than that of which any state could be capable. Precisely because the states are governmental bodies that break the national authorities' monopolies on coercion, they constitute the most fundamental bastion against a successful conversion of the federal government into a vehicle of the worst kind of oppression." This isn't just a matter of avoiding a speculative tyranny. Liberty is also enhanced by permitting people to make the choices that they prefer. Let me give you an example. A national rule is less likely to accomplish that outcome. So if you can imagine a federal union, for the moment, composed of two states of equal population, and assume that in one of them, I'll call it Urbania, 90% of the people would prefer a ban on hunting. But in the other state of equal population, which I'll call Rustica, only 20% would favor a hunting ban. So if you enact that at the national level, 55% of the people will be pleased. But if you leave that decision to the states, Urbania will ban hunting, Rustica will permit it. Now 85% of the people will be pleased. And what's more, hunters in Urbania are free to move to Rustica. And those who abhor hunting who live in Rustica are free to move to Urbania. That choice, both of freedom of movement and of how to arrange one's local affairs, is denied to the extent that a nationally uniform standard is imposed. Again, I want to reiterate, we're not talking about constitutional liberties that are required to be applied nationwide. We're talking simply about the scope of federal enumerated powers. So I think that the right to choose policies that suit the local citizenry is at the heart of the rights retained by the people. And that's why the command of the Ninth Amendment, that courts construe the grant of powers to the federal government in a way that preserves that right, is critical to the preservation of liberty. The Constitution is indeed a delicate design. It's structural. It's both a grant of powers and an assemblage of rights which sometimes trump powers. But I agree completely with Professor Beatty, who said, I believe in response to a question earlier, that the structural Constitution and the Liberty Constitution are really one and the same. And what I'm talking about is just a small example of how the structural Constitution is also a liberty-enhancing Constitution. The federal government is given enough power by the enumeration of powers to make the mechanism work. But it's not given enough power to where that machine can extinguish its makers and make them its servants. We, the people, are the makers of that machine, but we are not its servants. And that is the truth, which, like the air around us, is often overlooked. Thank you.